be as expeditious as we can, and we'll probably not be having any public testimony this afternoon, not because we don't, that's not our habit, it actually is our habit, but given the fact we've got a late start and there's another subcommittee that needs to come in behind us, we're going to go ahead and dispense with public testimony today. Of course, that will not preclude members from questioning the authors, including the subcommittee chairs who vetted out the bills initially. Mr. Bodie, we're going to start with, I think we've got a quorum. Barely. Mr. Bodie, we're going to start with your House Bill 67.
Yes, and Mr. Chairman, do you want me to
No, it's all right. We'll just do it from there.
Mr. Chairman,
Just push your button on the microphone there. There you go.
Mr. Chairman, I would like to present the substitute for House Bill 67. I have significantly modified House Bill 67. It is now going to make a new offense of carjacking in the second degree. And the reason for this particular bill is because of the rash of entering auto crimes in the state of Georgia, as well as taking crimes in the state of Georgia. So basically what I'm trying to do is create a new crime where if you enter a vehicle and you drive off with that vehicle and a person in the presence of another individual without their consent, it will be a new felony of carjacking in the second degree. The first offense will be 1 to 20 years. The second offense will be 3 to 20 years. And the third offense will be 5 to 20 years. And the reason for this is between 2016 and 2017, we had 766 additional aeronautical crimes. And we have also had a rash of very sometimes violent confrontation in South Fulton, as well as around the state of Georgia, with individuals either at the gas station pumping gas or at their mailbox getting mail, where individuals are entering their vehicles and driving off with those vehicles. What 67 is, I hope, does is that it will create a deterrent where individuals will not have to be in confrontation with individuals that are trying to take their vehicles away from them in their presence. So the big difference between carjacking in the first degree and carjacking in the second degree, of course, carjacking in the first degree, you have to have a firearm. You also have to have intimidation, violence. But in my bill, it's simply to deal with confrontation. So if you have a situation, in the example I gave in subcommittee, in South Fulton, a grandmother was pumping her gas at the BP gas station, and someone jumped in her car and drove off with her grandchild in the back seat. That is a classic carjacking in the second degree offense. And that is what I intend to deal with this particular offense.
Thank you, Mr. Bodie. A report from the subcommittee, Vice Chair.
Thank you, Mr. Chairman. The subcommittee unanimously passed this measure through. Representative Bodie, help me remember, your bill also fixed a flaw in current law, and can you help me, remember, because I can't recall it from reading it, but just walk us through the fix that this also achieves.
Well, one of the first things it did in the burglary statute 16-7-1, burglary in the second degree, which is typically dealing with commercial offenses or offenses other than breaking into someone's residence, it was a very obscure language in the code. Basically, it was stating that if you enter a vehicle which was unoccupied or occupied, that would have been burglary in the second degree. The problem is that no prosecutor I know, because I practice criminal law, uses that offense at all. It's not used. It's not something we deal with in the courtroom. So what we wanted to do is basically change that. We had individuals from PAC that testified that stated that the legislative intent was not necessary to have vehicles to be a part of that new statute that was enacted back in 2013, but it was on a laundry list of things that were submitted to the committee that passed. So what we want to do is create Erin Auto, which is already on the books. So Erin Auto is going to continue to be used, but it's dealing with entering someone's auto and not actually driving off, and it doesn't deal with presence. But we want to make Erin Auto a part of vehicle thefts, but also carjacking, second degree, where it's not a firearm. Then we still will have carjacking in the first degree, where it is a firearm, and you do use intimidation to take the vehicle. So it's more in line with a fluid criminal justice process and more in line with what we deal with in courtrooms today.
Questions from members of the committee? Ms. Silcox. I'm sorry, I'm just getting the line up here. Ms. Quick.
Thank you, Mr. Chairman.
Yes.
And to the author of the bill, just so I'm clear, what some of the new language in the measure does, as I understand it, is does create a new mandatory minimum sentence for for hijacking a motor vehicle in the first degree, correct?
No, respectfully, Representative, that language is already in the code. What happened is that we moved the language around to make sure we specify that carjacking in the second degree was not mandatory. So basically, if you look at line 42 and 43, we actually moved that language up to line 29 and 30.
Thank you for that clarification.
Thank you, Representative.
Any further questions from members of the committee? Seeing none, council, do you have any issues, questions? None. What's the pleasure of the committee? Mr. Trammell moves do pass by substitute LC 297418 ERS, second by the vice chair. Any amendments? Seeing none, any further discussion? Seeing none, all in favor of the gentleman's motion, signify by saying aye. Opposed? The ayes have it, and the motion is adopted. Thank you, Mr. Bodie.
Thank you, Mr.
Ms. Silcox, you want to roll? Okay. Just press the button there. Oh,
Quick.
okay.
Good afternoon, members of the committee and everyone who's joined us today. I am bringing to you today House Bill 293. And House Bill 293 is really just a cleanup of existing law. If you look at the code section, the substantive section of it itself, you'll notice that there's nothing underlined, there are no changes. The only two lines that are underlined are line 21 and 22, and that really is to change the effective date to hopefully the date of the governor's signature on this bill. Because if you go back, this language up above, this was originally passed in 2013, and when it was passed, it said specifically that any offense occurring before July 1st, 2013 shall be governed by the statute in effect at the time of such offense. This just clarifies and makes sure that that as stated in the code section up above, lines 12 through 20, that the evidentiary standard for the admission of child hearsay in a court case would be at the time of the trial instead of at the time of the offense. So it really is, I think, an important substantive improvement in the code, and would appreciate your consideration and support.
Is it fair to say it's a clarification that both the prosecution and the defense have sought, just to have clarity in the process?
Yes, Chairman Golick. My understanding is the defense has used this frequently as a tool to eliminate hearsay being admitted based on the differing evidentiary standards at the time of the offense versus at the time of the trial.
This bill did pass unanimously through subcommittee, and it simply is a technical fix. I don't think that there was this intention that created these different gaps in the hearsay rule. So this will create clarity for everybody involved.
All right. What's the pleasure of the committee? House Bill 293.
Move to pass.
Second. Quick moves do pass LC 297366, second by the vice chair. Any amendments? Seeing none, any further discussion? Seeing none, all in favor of the gentlelady's motion signify by saying aye.
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 Opposed? The ayes have it, the motion is adopted. Thank you, Ms. Silcox.
Thank you.
It's one of those little bills that really flies under the radar, but it's very, very significant. Thank you for doing that. We'll call 116, House Bill 116. Vice Chair.
Thank you, Mr. Chair, and I'll just present from here. I have Assistant District Attorney in Cobb County, Jesse Evans, is here if there's any questions. He's a subject matter expert on this issue. But just to very briefly recap to the committee, we had a nearly 3-hour subcommittee hearing on this issue, and I do not want to reinvent that. But in the fall of 2016 or late summer, there was a police shooting in Cobb County. I know there's some folks from the Marietta Police Department here, and is Officer Davis in the room? He's outside. Okay, I know that there's not room in here, but Officer Davis is here outside the room. He responded to a call of entering auto in the middle of the night, and responded on scene and found 2 individuals entering cars, and was essentially met with gunfire. He was shot twice. A third bullet actually hit his gun and missed hitting what the trajectory of which was probably aiming towards his, or would have hit his abdomen. So very well may have saved his life. But he 5 surgeries later and several months of rehab is back on patrol. He is outside, but is here, and I wanted to recognize him. But in this particular case, the shooter was arrested. I was a 15-year-old. And it was, it's been reported that he was identified. Here's Officer Davis in the room, just so everybody. It has been reported in the media the individual that was arrested is a 15-year-old juvenile associated with the Blood Street gang, and also has a juvenile criminal history, and was committing a felony upon the time which Officer Davis came upon him, and he shot Officer Davis multiple times, at point blank range. The District Attorney's Office, based on all of these factors, it's my understanding that they filed a petition according to the juvenile court process in order to try to transfer the shooter to Superior Court to try him as an adult, and that petition was denied by the juvenile court judge. And if you look at the factors that the law in Title 15 lays out 11 factors that the juvenile court judges to consider with these petitions, and literally the facts alone that were made public, you can argue that all 11 factors were met. There was a lot of testimony on this issue at the last hearing, and even though there's and many folks, I believe, testified to the kind of inexplicable nature of this judicial decision. As you probably can all understand, this has shaken the Marietta Police Department and the community. And Chief Flynn had called me in the fall to ask me, what can we do to make sure that this never happens to an officer again? And so I began working on this issue. The original form of the bill that you have in front of you has 8 offenses that currently existing policy. These 8 offenses allow a district attorney's office to indict a case directly into Superior Court without seeking the consent of the juvenile court judge. So what I originally sought to do was to add aggravated assault with a firearm and aggravated battery upon a peace officer and some other groups to this list, so that it would be, instead of 8, it would be 10 offenses. So we had, like I said, a 3-hour hearing on this issue, and there was a lot of really great testimony on both sides of this, and I do believe in the process. My original bill opened up the victim class to essentially all victims with aggravated assault with a firearm, but there was a lot of testimony about concerns about the overbreadth of that. And the process at work, I made a decision based on all of the feedback and what we did during the that committee hearing that day to really rein this in and narrow it and have its application be just to police officers. And so what you have in front of you on page 2 on lines 26 through 30 adds 2 offenses: aggravated assault upon a peace officer according to subsection D or F of 16521, which is aggravated assault. Section D is peace officers, and Section F is correctional officers. And then in line 29, aggravated battery. And the reason why aggravated battery is necessary to this is that if you shoot someone in the back and they aren't aware that they're being shot, then there was no assault, and therefore there's no aggravated assault. And so to close that gap, aggravated battery, it would be the appropriate charge in those circumstances. And so again, we've limited it to subsection C and E, which is the peace officer and the correctional officer section of that. The other major changes in lines 40 through 42, we have a more narrowly defined firearm for the purposes of this code section. Currently, and it's essentially defined that to be, for lack of a better way to say it, a real gun. So this would essentially eliminate the ability for a toy gun, if somebody was using a toy gun, to be to have their case, whether it be for either of these charges or existing armed robbery with a firearm, for those cases to come straight to Superior Court if the gun was not a real gun. And so I think that, again, that's, I believe, an effort in restraint. All of the other code sections of this are simply some changes that occur in the juvenile code that are because of the mechanics of Part 1. The last thing that I want to say is that some of these offenses that are currently on the list of 8, half the offenses, it's the sex crimes, the Superior Court judge has essentially the final say of authority in if a case is indicted and goes to Superior Court, then they have the ability to override the district attorney's indictment if they feel that, according to the 11 factors that are laid out in juvenile code, that the case needs to be in juvenile court. Currently existing law includes the 4 sex crimes that are on the list. I added both of these to that because I felt that this issue, it's just all about discretion. And I believe having 2 elected officials, one, an elected district attorney who can choose whether or not to, under these circumstances, could make a choice of whether to bring someone to Superior Court or to send them to juvenile court if they felt that was more appropriate. If they choose to indict, then there's that second and ultimate layer of discretion, and that's the Superior Court judge would have the ability to send the case back to juvenile court for its final prosecution or whatever it is that will happen with the case. And so those are in lines 34 and 35 is where that is achieved. I think this bill represents a significant work of compromise. I'm comfortable with it. I believe that this bill offers a protection to our police that's needed. I think the statement is that no matter how old you are, if you're going to shoot a police officer or pull a gun on a police officer, you've sailed beyond juvenile treatment, and you will potentially face charges as an adult. I believe that we have struck the right balance on this, and I hope for your favorable consideration on this today, and if there are any questions.
I mean, just to be clear, their discretion still is retained by the Superior Court judge as to how the juvenile will be treated, right?
That's right. Right now, that's right. Right now, the juvenile court judge would have to consent to transfer the case to Superior Court. This would ultimately just move that from the appointed juvenile court judge to an elected Superior Court judge.
Okay. Questions from members of the committee, Ms. Price?
The Speaker, in his infinite wisdom, placed me on this committee. Not being a lawyer, I may ask some very stupid questions. However,
No, it's just a different perspective that's probably a very healthy one, frankly.
well, in that case, I'm not shy.
Tell me something I don't know.
Is there a difference in a loaded and unloaded gun? I mean, I know there is, and I'm looking at line 41, converted to, but for other purposes, is that irrelevant?
As using a firearm would mean a handgun, rifle, shotgun, or other weapon which will or can be converted. So an unloaded gun would also qualify as a firearm under this.
Okay, so brandishing an unloaded gun is equal punishment.
Not equal punishment. It's a conduct or an action that would allow the DA's office the choice to directly indict your case into Superior Court, as opposed to requesting a juvenile court judge to consent to that. Punishment would ultimately be decided in whichever court the case was resolved in.
I'm getting there.
Okay.
Thank you.
Any further questions for the author? Seeing none, what's the pleasure of the committee? Mr. Strickland moves due pass of House Bill 116 by substitute LC 297401S. Is there a second? Second by Ms. Kendrick. Are there any amendments? Seeing none, any further discussion? All in favor of the gentleman's motion signify by saying aye. Opposed? The ayes have it, and the motion is adopted. Thank you, Mr. Reeves. Mr. Clark, you ready to roll? All right. Come on up. You can move closer to the microphone. No, I mean, that chair is not a hazard to my knowledge, so you'll be all right. Try that. David, try that one. Go again. Oh, sorry, wait.
Now, thank you, Chairman, for hearing my bill. It's House Bill 124, and it's a substitute. It's LC 440307S, and it's a bill that I brought last year, that passed unanimously on the House floor, and I had back in 2015 chaired a Welfare Fraud Study Committee, and the prosecuting attorney counsel had asked for me to carry this. This is just more cleanup language and putting this in Title 16, putting welfare fraud in Title 16 where it should have been all along. And so, same bill as last year, some cleanup, and they had requested it.
We have new members on the committee, so some of us have the benefit of having gone through the bill last year, some of us don't. So if you could give us just a few minutes of your process on how the bill started and why it came about and so forth. I know you chaired a study committee, correct?
I did back in
And
2015.
if you could just give us a few minutes on that background, the result of that, which is this bill. I think that would help with broader understanding of the intent.
They had what this bill does. It's not increasing the penalty or the on people who create and do fraud, but this is just helping them more be able to point and say, hey, here it is in Title 16. It is fraud. It is wrong, and it's not increasing it so they can put more harsh punishment on them. It's just more cleanup. It's more saying, hey, guys, if you're taking from the truly needy, you're going in and getting all this extra stuff, you know, it's wrong. It just helps them more clearly be able to point and say, hey, it's here in Title 16 of the list of crimes.
Okay, so it's
And
more of a structural change to our law
Exactly,
as
Chairman.
opposed to a substantive one. Is
Exactly.
that a correct statement?
Yes, sir.
Okay.
Say that.
Questions from members of the committee? Seeing none, what's the pleasure of the committee? Vice Chair moves due pass of House Bill 124, LC 40. I'm sorry, Council, did you have any issue at all? Okay. Vice Chair moves due pass of House Bill 124 by substitute LC 440307S. Is there a second? Second by Mr. Strickland. Are there any amendments? Seeing none, any further discussion? Seeing none, all in favor of the gentleman's motion, signify by saying aye. Aye. Opposed? The ayes have, and the motion is adopted. Thank you, Mr. Clark.
Thank you, Chairman.
We'll call finally House Bill 343, Mr. Hilton. I think that one works.
Thank you, Mr. Chairman. Thank you, Mr. Chairman, members of the committee. I'm here today to present to you House Bill 343, which is LC 372338. This passed out of the Setzler Subcommittee unanimously. This bill that I'm proud to present to you today essentially does a kind of find, replace type process in the bill, replacing the words mentally retarded with intellectual disability. The word retarded is one that served a clinical purpose for a number of years, but is now deemed as one that can be used to as offensive and hurtful to a number of people in the disability community. And so we would like to move forward with replacing that in the code. As far as the discussion in committee, it focused primarily on the last page of the bill, 262 down to 272. There's questions around, it seemed kind of duplicative there, I guess specifically 263 to 267 and then 268 to 272. And it was dealing with kind of cases that are already in process, and then those that start as of July 1st, 2017. So that's why that kind of repeats there. I will draw your attention to lines 269 and 271. I do think we need to add "but with intellectual disability" on 269, and then on 271 charged "but with intellectual disability." That will keep the language consistent with what you find on line 18 on the first page, "guilty but with intellectual disability." This was recommended to us by the Georgia Association of Criminal Defense Lawyers, and I should point out that we've had considerable help on this bill from the Prosecuting Attorneys Council of Georgia and a number of other organizations who have looked at this and signed off and have been a big help to us. I should also state that in 2010, at the federal level, Rose's Law passed and replaced mental retardation in the federal code with intellectual disability, and this did not have any change definition-wise on policy, practice, or existing case law. So willing to open it up to any questions. I apologize because I filled this room, I think, with a fan club here, so
Just out of, do we have a situation where there's been a plea? Has there been a situation where we've had a plea of guilty? And I guess in years past, the antiquated term of mentally retarded. So if there's been a plea of guilty but with mental retardation, let's say, to this point, have we had a situation where the court has accepted a plea and imposed the death penalty regardless?
That's a good question. I can't think of one now.
Okay.
Yeah. And this really, again, is kind of a word change, not meant to change anything having to deal with death penalty and those types of issues.
Well, I'm just looking. I'm going to the motivation of lines 268 to 272.
Mm-hmm.
So I'm asking myself, why is that necessary? In other words, if there's been a plea of guilty but with intellectual disability, to this point known as retardation, it's mandating the death penalty shall not be imposed and the court shall sentence the defendant imprisonment for life. My sense is that if there's the guilty plea, that's in exchange for the individual's life as part of the plea agreement.
Yeah.
I'm just curious as to, have we seen a situation where there's been a plea where there's been guilty, but there's also been a statement's not the proper word, but there's been a mental retardation recognized by the court, and yet there's still been a death penalty imposed. I was just curious as to, because that would be the underlying foundation for why a paragraph like this would be necessary.
Mm-hmm.
That's why I'm asking the question.
That's a good question. None had been brought to my attention.
Okay, just
Yeah.
curious. Mr. Setzler, do you have a subcommittee report on that?
Yes, Mr. Chairman,
Thank
I was
you.
going to speak to that. And,
Okay.
The subcommittee, we tracked this, and this bill really, but for those last lines, really was a kind of a word-for-word replacement. Really, most of the discussion in the subcommittee centered on that issue of that last paragraph, lines 268 through 272. Our goal was to make sure we were tracking, and there wouldn't be some change in case law because we're using a new term, that it bridges naturally. We did have the Prosecuting Attorneys Council. Their death penalty expert was there and actually spoke in subcommittee and spoke to the issue of the term being able to bridge over, and also no change to the burden of proof. That would track the same way as well. That we'd not be creating the potential for new law to be litigated. We did kind of discuss that. I think and as I said in subcommittee, when we open up anything related to the death penalty, we proceed even more slowly than usual. And it was our belief that having both paragraph 1 and 2 allowed previous cases to move forward unchanged, and anything that could come up if there was a something that, again, in the interim between now and July 1st, would be brought with this. There's no change to current law. Our goal was to make sure there's no change and that we have sort of stasis. Now, I don't want to contemplate any potential fact pattern. We were just trying to make sure there's stability and no change from the current status quo.
I was just curious about the paragraph because I didn't have the benefit of the subcommittee meeting, but I appreciate the perspective on it. Ms. Quick.
Thank you, Mr. Chairman. And to your point about this section, perhaps someone can tell us, but it very well could be, I have some vague recollection, that this could be simply a statement of the case law on this point. But and new statutory language. Someone who's an expert may be able to tell us, but the chairman is right. I believe it's new language.
Ms. Travis, do you have any perspective on that? Oh, I'm sorry. 37. Yeah, I'll grab it. I'll be at ease for a minute. I want to get Mr. Porter in here and just get confirmation on that, just to close the circle.
It might be, but I just don't know.
Mr. Porter, thank you for coming in. Appreciate it. Ms. Quick, do you want to address your question to Mr. Porter, or I can, whatever?
Yes, Mr. District Attorney, we are discussing HB 343 in terms of these wording changes from mentally retarded to with intellectual disability. We're discussing the new language on lines 268 to 272, and the chairman had a question about where that came from, and I said we may ask an expert, but we might find that that is a statement of existing case law.
Well, what we did was we looked at the bill from the perspective of, if you go earlier back, with an intellectual disability contains the same definition as the existing statutory definition of mental retardation. And so if you substitute in where it would be guilty but mentally retarded in a death penalty case would automatically prohibit the imposition of a death sentence. So if you're just substituting words, then it would have no effect on prior case law because the actual bill defines with an intellectual disability as what we now call mental retardation.
But to the chairman's question, this appears to be new language, and the question is, was it replacing a statute, which it doesn't look like, just to us in terms of what we see, or is it a statement of existing case law?
I'm not sure I understand your question.
That
New language being...
Well, it's lines 268 to 272 of the bill, which we can...
Mr. Chairman.
I think the July 1st, 1988 date, which is further up, is when the Supreme Court case came out about that you could not execute a mentally retarded person. And so you would have to have an effective date. That was the first time a verdict of guilty but mentally retarded could be imposed. And then the second paragraph from 268 to 272, I think, brings in this bill effective date of July 1st of this year.
So is that simply in alignment with the 88 case? Is it? Okay.
It's
Okay.
Mr. Chairman.
Okay.
It's word for word the same. It just
Right.
restates it so that you have cases that are in the process right now from 88 until July 1 of 17 that 263 through 267 exists for, unchanged, untouched, untampered with. and then it's literally a word-for-word lift replace in 268 through 272.
With the exception at 269 and 271, there appears to be the words with a intellectual disability left out of,
We'll clean that up.
but that's just a
Word
typo.
with.
Okay. I think we got clarity on that, which was, I think, the collective suspicion, but we just needed to hear that out loud. Okay.
And then I understood one of the questions was, has there been a mentally retarded person executed, and that's a subject of a debate. I would
Well, not one who's pleaded guilty.
no,
Pleaded. We just looked at the section, but there's not one there's been no execution when the individual's been pleaded guilty as per the 88 case.
correct.
Right.
No,
Okay.
That once the person they plead guilty but
Right.
mentally retarded, there would be no possibility.
Okay.
Of execution. Prior to that,
Right.
it's a subject of a debate.
Thank you. Any further questions for Mr. Porter while we have him here? Thank you, Mr. Porter. Any further questions for the author from members of the committee? Mr. Setzler.
I do have a question. It came up, and I've been very sensitive to this issue from Subcommittee 4, and I'll ask Mr. Porter since he's here now. In your opinion, and or in other states, has the term intellectual disability been read to be a broader term than mental retardation? I mean, I can imagine, just in the vernacular, the term intellectual disability being broader.
I can give you the famous lawyer's answer, it depends. In general, you have to go, but intellectual disability is contained in the DSM-5 as a defined term of certain types of disabilities, and so that is broader than what we define mental retardation as. But I believe that, given the fact that in Georgia law and in this specific bill, it defines with an intellectual disability as what we now call mental retardation, I don't think there's a possibility of that becoming more expansive. But and there's certain case law on the federal level that says that if that's the intent of the statute, then it's limited.
So in spite of DSM-5 being broader, because we define it in statute, it's limited to statute, and federal case law supports
the
that.
DSM is the diagnostic and statistical manual that mental health professionals use to diagnose mental illnesses. So that would not really have any bearing on the statutory definition.
To build on Mr. Porter's comments, if you refer to lines 52 to 61, essentially, again, it's kind of a word-for-word lift of where we define in the code section intellectual disability means. We essentially, there's a definition on 59 to 61 of mentally retarded. Take that, use that, insert. So the code section defines and it keeps it the same as it was.
Thank you for that reference. That's helpful. Ms. Quick?
That's left over.
Oh, okay. All right. Any further questions for the author? Seeing none, what's the pleasure of the committee? Vice Chair moves due pass of House Bill 343, LC 3723338, second by Mr. Setzler. We're not quite done yet. Not quite done. Are there any amendments? Seeing none, any discussion? Seeing none, Ms. Travis, did you have?
Well, a couple. One was, I think you need to add the word with on line 269 and 271 before the word intellectual to be consistent with the language elsewhere.
I'm sorry, say again?
On line 269.
Yeah.
After the word but, insert the word with, and the same on line 271. But with intellectual disability, that's the language that's used throughout, but wasn't brought forward there.
Are there any other instances that you've seen in the bill where the with scenario, or just that?
Oh, yeah, there's plenty of times where it's used with. Look at line 18, look at line 29, look at line 42.
I mean, where the with is left out.
Oh, no, these are the only two instances.
Oh, okay.
left out.
All right.
And then I had a couple other things.
Okay, let me offer that. Then let me offer as an amendment line 269 after the word but, inserting the word with. And on line 271 after the word but, inserting the word with. Any objection to those amendments? Seeing none, they're adopted. Ms. Travis?
For your consideration, generally lines 7 through 10 are what I would consider legislative findings, and we usually refer to that in the title of the
recommend to provide for legislative finding in the title of your bill.
Any objection to an amendment to that effect from the committee? Any objection? Hearing none, well, it's adopted.
And then with respect to lines 8 through 10, I had a suggestion that I think would make it read a little bit clearer. So I'm going to read it out. I'm going to say it out loud the way I think it might read a little better, and then I'll tell you the specifics of the changes. Starting at line 8, the General Assembly finds that for purposes of existing case law, when a case refers to or uses the term mental retardation, mentally retarded, or intellectual disability, such terms shall have the same meaning and shall be interchangeable. The changes would be on line 9, replacing the word and with the word or. On line 8, inserting after the word law, when a case refers to or uses, striking the word regarding and taking the S off of term on the end of line 8.
Any objection to those changes as one amendment? Any objection? It's adopted. Anything further that you can see at this point?
No, sir.
Okay. Thank you. I appreciate that. So now on the underlying motion of do pass now by substitute of House Bill 343, are there any further amendments? Seeing none, any further discussion? Seeing none, all in favor of the underlying motion of do pass by substitute signify by saying aye. Aye. Opposed? The ayes have it and the motion is adopted. Thank you, Mr. Chilton. All right. Members of the committee, that concludes our business. A couple of housekeeping matters. Mr. Hilton, also, Mr. Hilton, you're going to need to go to rules to fill out a form. That way you can get on the consideration calendar. And then you can have the pleasure of seeing Mr. Meadows tomorrow morning at 9 a.m., which is always a really fun experience. But members of the committee, I anticipate our next meeting will be on Monday. I anticipate it being a longer calendar. I also anticipate that House Bill 65, there'll be a substitute for your consideration at that meeting, but the chair will send out that substitute. The goal is to have that sent out by the end of the week for your consideration over the weekend. And we'll certainly send out a general notice about the agenda on Friday at the very latest, but I just want to give you a heads up that 65 is likely to be considered on Monday. Anything else for the good of the order? Seeing none, we're adjourned. Thank you.